Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today, we are joined by Paul Cahill. He is a partner at Will Davidson LLP, and we're going to talk today about his career, looking at personal injury litigation, medical negligence, and again, a lot of the tribunals and courts that he practices in there. So, thank you so much, Paul, for joining us, and maybe you can start by telling us a lot more there than what I did there in a few seconds there about yourself and how you got into law and in your practice today.
For sure. Well, thanks very much for having me here today, and I'm looking forward to sharing my experiences with the people watching. So I went to law school at the University of Ottawa, and I finished in 2004. At the time of me going there, I was really interested in the practical side of law and representing people. I'm not sure, where that came from. Probably ever since I was a kid, I loved watching courtroom dramas and sort of the thrill of being in the courtroom. And there's always sort of an attraction for me to get into something like that. So that's what drew me into law school. While I was at law school, what I really liked was working at the community legal aid clinic. So the University of Ottawa had a clinic, and we had different divisions for different areas of law. And I started in the landlord-tenant division, and I was battling it out against negligent landlords, the slumlords that were providing poor tenancies to the people of Ottawa. And I had a great time bringing applications at the landlord-tenant tribunal and getting compensation for people. Although at the time it felt like a lot, it was probably $500 or $1,000 for someone. But at the time as a student, it felt like it was a big win. I also got into criminal defense. So there was a criminal division, which I was really attracted to because of the amount of court time that was involved compared to any of the other divisions. And so I spent my law school years mostly spent at the clinic working on cases while kind of fitting in my studies in between that as much as I could. Once I got out of law school, I applied both to civil litigation firms and also to criminal defense firms and Crown offices. As it turned out, the articling jobs that I was offered were all in the civil litigation field. And I ended up accepting a position here at Will Davidson. It was called something else at the time, but it was still this firm. And it was to do basically plaintiff personal injury litigation and insurance defense litigation, because my firm does both. And that was really something that seemed like a good idea, but I honestly didn't know what personal injury litigation was coming out of law school. I really had no conception as to how much legal resources are spent on this specific area of law, how much money is at stake, and how much courtroom time is actually spent on these sorts of cases. So it was a bit of a learning experience for me. One of the things that I got to do, which was a huge, I think, catapult for my career into medical negligence, was as an articling student, the senior partner at the firm, Gary Will, he had a big case going on in Kingston. It was called Williams versus Bowler, and it's a reported decision. And it was a case involving a misdiagnosis of a subarachnoid hemorrhage that led to catastrophic injuries in a woman, and it was going to trial. So it's basically, as soon as I started my articles, I got pulled into this case and worked on it pretty much for 80% of my articles. And that was, I did the trial with Gary and helped with the appeal afterwards, which ultimately settled. And that kind of formed the foundation of where I wanted to go with my legal career. Even though Will Davidson does all kinds of personal injury insurance defense, and we were doing some medical negligence at the time, but it was something that I felt was a real opportunity for me to get into, mostly because a lot of people didn't want to take these cases. Medical negligence cases were like hot potatoes. A lawyer would get a phone call for one and they quickly pass it off to another lawyer, not wanting to take it on because of the concerns about fighting the CMPA, the Association of Defense Doctors, how expensive it is, how risky it is. So a lot of people didn't want it. So as a young lawyer in, I guess, 2005, and starting my career, I thought to myself, well, here's an area of law where it's not as competitive. We've all seen the billboards of personal injury lawyers looking for motor vehicle accident claims or slip and falls or long-term disability claims. But back then, and even now, there's a lot less competition and there's a lot of work in the area. So it seemed like a great area for me to get into. And then over the course of my career from then until now, that's basically what I've focused my attention on. And it's been amazing so far.
Perfect. So maybe you can And we were talking about this just before we started here about sometimes there's that disconnect of understanding tort law, and we learn about medical negligence cases in law school. But in terms of practically, maybe you can walk us kind of through the process. Like someone comes in and said, "Hey, I went to the hospital and they butchered the surgery or whatever." Paul, how can you help me out? Maybe you can kind of give us a medical malpractice kind of 101 here for us.
100%. So I think the first thing to know is anybody watching this who's a paralegal student or a law student or a lawyer, I think the first thing to know is what is the law as it relates to medical negligence. And one of the things that I love about medical negligence is the law is actually pretty simple. And there's not a lot of fighting about it or what it means or how it should be interpreted. The basic premise is this. In order to be successful in a medical malpractice claim, you need to prove that the doctor or healthcare practitioner fell below the standard of care. So you need to prove what the standard of care is, and you need to prove that the doctor fell below it. So that could mean for a patient who comes into the emergency room with left lower abdominal pain and nausea and vomiting, that they should get an ultrasound to rule out appendicitis. That's the standard of care. You have a patient who came in with those symptoms and they didn't get an ultrasound. And it turns out that they had appendicitis and their appendix bursts a few days later and they get really sick and maybe die. So that would be a very practical perspective of what the standard of care is and proving that it wasn't met. The other essential element to establishing malpractice is something called causation. So you need to prove a causal connection between the substandard care and the harm that's ultimately happened. And that's probably in most medical negligence cases where you have the most practical challenges and proof. But effectively, you have to prove that the negligence or the substandard care caused the damages that you're complaining of. And then obviously, you'd have to prove the damages in any other way that you would have to in a personal injury case. From a practical perspective, how I manage cases or I deal with cases that come in through my office is I'll get a sense of what the person's history is like, so they'll tell me what happened. Using experience, I'll decide whether I think this is worth having a closer look at or not. And if it is worth having a closer look at, I'll get all the medical records because the medical records will form basically the foundational evidence for what happened. And then I'll start consulting with experts. So effectively, in order to prove the case, I can't just go into the courtroom and explain to the judge how awfully my client was treated in the hospital and therefore they should be compensated. I need to prove what the standard of care is. And that's something that the courts have uniformly determined has to be done through expert evidence. So I find an appropriate expert to give that evidence. And it generally has to be the same kind of specialty physician as a physician that you're complaining about. So if you're concerned about a urologist, you need to find another urologist to come in and testify about what the standard of care was and whether it was met in this particular case. So I need to find someone to basically testify in court on behalf of my client. From a purely practical perspective, if I can't find someone to support the case, then I tell the client there is no case. The association that defends physicians almost never settles a case unless you produce an expert report. And the only times that they may do it is when it's so patently obvious that there's negligence, so there's really no point in putting you through the ringer of getting the evidence. But that's a very rare case. So you need to get the evidence. And if you can't get the evidence, they're not going to settle and you're going to lose at trial or by summary judgment. So that's sort of the first major step, is to find the expert evidence. Once you have all the expert evidence that you expect you're going to need, then it's just like any other civil litigation case. You issue a statement of claim, you go to discoveries, you go to a pretrial, and you go to trial. But I think that the defining difference is in needing to do that groundwork at the beginning to make sure that you have the experts lined up who will come to court and testify on your behalf if you need to move forward with the case to trial.
So I guess is there a distinction there in getting that expert to report earlier on in the process rather than maybe in a motor vehicle accident where that might come a little bit later, in case they're not looking at settling? Does that matter kind of when you get it, or would you not really go far until you have that report in hand? And as you said, if it's not going to be produced, then there's nothing really to the case. Is that sort of a fair assessment?
Yeah, exactly. I mean, there's always a sort of a business reality of any kind of practice of law. And the business reality in medical negligence is these cases are funded by the law firm. Sometimes we'll ask for upfront monetary retainers from clients to help fund the initial investigation, but it's usually pretty minor and it's not going to cover the full cost. So if I decide that I think this is a great case and I just go off with a statement of claim and I go to discoveries and I'm spending all kinds of time on the file, but I've never consulted with an expert, the risk is that if when the time comes that I need to, and I ultimately will have to, I can't find someone to support the case, then I'll have to abandon the case and I'll have to write off all the time and money that I spent on the case. Kind of like in it's a little bit different in motor vehicle accident cases. And I tell people it's different for this reason. Most of us are drivers, right? So we know how to drive a car. And when an accident happens, once we hear how the accident happened, we can usually figure out who's at fault for the accident. You don't need, and we know that the injuries that were sustained in the accident were caused by the accident, right? They weren't caused by anything else. In most cases. So you don't really need to go through that process. So a lot of personal injury lawyers who typically do the more general personal injury cases like motor vehicle accident claims and stuff don't have the mindset of, oh my God, I got to really figure out whether I have a case or not before I put a lot of time and money into this. Otherwise, I might risk a big write-off down the road. Whereas, if you do this a fair bit, you only have to get burned a few times to realize, hey, you know what? I'm not going to take anything for granted that this is a slam dunk case. I'm going to find my experts first. You don't necessarily get a full expert report, but you definitely would have a phone call with someone, get some reassurance that there's something to this case, and go to discoveries. And then once you're done discoveries, get the transcripts and get the full reports and set it down for trial.
And one thing that's come up, I think when we broach this in tort law, I think I always use the example for students to relate. It's kind of like in a TV show, Grey's Anatomy, where I think one of those doctors dies because they were at maybe a hospital that doesn't have as much resources as one of the bigger ones, right? So, I mean, is that the same thing in terms of in reality, right? I mean, if someone was practicing out of something maybe up north where they don't have the resources of, let's say, a sick kids, are they held to a little bit of a different standard, or is it kind of just what a reasonable professional in that field? And as well, I mean, does that relate to if it's like a general practitioner versus a specialist, as you pointed out? How does that kind of all play into what sort of the level of negligence needed to really advance a case here?
That's a really good question. So there is in the medical malpractice jurisprudence, there's something called the locality rule. And the locality rule basically said that the standards of care for medicine in Ontario, let's say, or in Canada, should be the same no matter where you are. And that's because we have a government-funded, government-administered healthcare system that should be the same no matter where you are. Now, and I think that's true, but I think there's some practical realities to that. And one of them would be, for instance, if you were really far away up north and you had a medical emergency and you went to your local hospital, your community hospital, and they appropriately diagnosed you with, I don't know, an aortic dissection or something serious that required urgent surgery that couldn't be done at that community hospital because they don't have the resources there. And I don't think anyone would suggest that every hospital has to have cardiac surgeons on call 24/7 to operate. So you end up in a hospital that you require urgent treatment by a very specialized kind of surgeon. And because you're so far up north, they transport you by air ambulance or ground ambulance or wherever to the nearest tertiary center where you can get the care that you need. But because of where you are, it takes a number of hours and you die in the process. Whereas if you had been in Toronto when that happened, you went straight to Sunnybrook, you would have gotten surgery right away and you would have survived. So, I don't think it's necessarily negligence that someone's 2 hours away potentially from the kind of treatment that they need because of distance. But so long as the standard of care was met in terms of identifying it and transporting it as soon as you can, then you'd probably be okay. The other question you have had, which I think is really good, is this idea that there are sort of different levels of specialty. And that always sort of comes up in medical malpractice cases where, you have a distinction between what we'd call a community obstetrician, which would be an obstetrician who practices in Thunder Bay or North Bay or something in the community, versus a tertiary care obstetrician. So that would be an obstetrician who practices at Sunnybrook doing high-risk pregnancies. They're both obstetricians, and they both should effectively have the same standards when it comes to treating patients, but one of them, they're in vastly different settings. And how we handle that from a practical perspective to avoid getting into the kinds of arguments that will be raised when you go to trial is if you're suing a community obstetrician because of some kind of mistake that they made, you might be better off finding another community obstetrician to comment on the issue of standard of care rather than going straight to the most qualified, prestigious, credentialed obstetrician in all of Canada to point his finger down from the ivory tower saying that this person up north really screwed up because they missed something that, at their institution, everyone knows, including the residents. So I think that, it depends on the facts of the case. There's some things that are so obvious in medicine that it doesn't really matter, but in some cases it does. And how you deal with that and mitigate against those sorts of arguments is you try to find, as much as you possibly can, the same sort of expert to comment on the defendant that you're suing.
And does it matter in terms of like years of experience? Like, what if you just started as a cardiologist, and are you held to a little less standard compared to someone who's been doing it for 10 years?
No, and in fact, even residents and fellows are held to the same standard as doctors. So there is once you're practicing medicine, you're held to the same standard as all physicians in that field. Just like in law, you can get called to the bar and go to the Supreme Court of Canada the next day representing a client, and if you really screw it up, you can't say, well, this is my first day on the job, it's not my fault, I didn't know. It's really, once you're a lawyer, you're a lawyer. Once you're a doctor, you're a doctor. It doesn't matter if you've had 1 year experience or 50 years of experience. You're held to the same standard.
And know that standard, right? I mean, it's not it's not perfection, right? I mean, not every surgery that you're going to do that has a risk is going to result in someone's life being saved or a successful operation. So kind of how do you, when you're going into that case, and how do you kind of look at establishing, I mean, through the expert, I guess, where was there maybe a departure from that standard, or kind of where does that line in the sand, so to speak, stand?
Yeah, I mean, every case, and you can imagine these cases are very factually driven. So every case will turn on the facts. But you're 100% right. It's not a standard of perfection. And outcome, the standard of care is not supposed to be, or is not to be determined with hindsight. So we're not, looking backwards at a bad outcome and trying to find fault or blame with the physician. You have to look at it prospectively. So you're looking at what the physician was doing with the knowledge that he or she had at the time of the alleged mistake or malpractice. And did they act reasonably in the circumstances, similar to how a reasonable and prudent physician of similar training would have at the time? That's basically what the law says. So how do you sort of deal with that? Well, I think when it comes to a surgery case, as you mentioned, surgery cases, any kind of surgery has what we would call recognized complications. So recognized complications are known to occur, in all surgeries at a certain amount: bleeding, infection, damage to, certain vessels, these sorts of things. And if you have a case where a person comes in and has a surgery and comes out with a recognized complication, those are very challenging cases to establish that the surgeon fell below standard of care because it was a recognized complication. That being said, there are certain standards that need to be adhered to during particular surgeries. And one that comes up often in my practice is that of a ureteric injury that happens in a hysterectomy. So your ureter is a sort of a vessel that runs from your kidney to your bladder, and as your kidney purifies or cleans your blood, it creates the output of urine, which goes through your kidney down the ureter into your bladder. And each ureter runs on, there's 2 ureters, one on each side of your pelvic sidewall. And the standard of care in performing a hysterectomy while you're taking out the uterus is to identify the ureter to ensure that you don't accidentally damage it, because it's one of those things that can be quite easily damaged if you aren't aware of where it is, and make sure that you stay away from it. And so what comes up sometimes is you have a damage to a ureter and a person complains about it, and the defense is, well, that's a recognized complication. And it is a recognized complication. But the standard of care requires the surgeon to identify the ureter to ensure that it's not damaged. So when you go to the operative report and you see that the surgeon in dictating the surgery doesn't mention that they identified the ureter, which is an essential step of the surgery to prevent this from happening, you, I think, would be on solid ground to say, well, there was negligence because they didn't identify the ureter, which they were supposed to do. And the outcome was that it got damaged. And if they had dictated or identified the ureter in their note, then they would be on better ground to say, well, I did it. I did everything I was supposed to do, and it still happened. And so what more can I do? But where you find that there were aspects of the surgery that appear not to have been followed as they should have been, and you get the complication that you would expect to see happen when they're not followed, you can convince, I think, a trier of fact that there was a breach of the standard of care in that kind of a case.
Well, are you primarily then working on the plaintiff side there, or do you do any on the defense side at all for, I guess, not necessarily medical malpractice, but no, anything in civil litigation, personal injury?
No, no, I don't do any kind of defense work generally.
So maybe talk a bit about some of the tribunal work that you do there on the plaintiff side there. I know paralegal students who can appear in some of those boards, and you can maybe highlight one or two that you've done, that you've gone before, and kind of how that process takes place.
For sure. So I don't do a ton of tribunal work, but I'll give you some anecdotes of what I've done. So one of them that we go to in the medical malpractice field is the Health Professions Review and Appeal Board. That's a tribunal, and it's basically the review board from the College of Physicians and Surgeons of Ontario and any other health regulated health disciplines that have their own colleges. So every health discipline, like dentists, physiotherapists, respiratory therapists, they'll have their colleges, and if there's a complaint, there can be discipline that happens at that level. If someone wants to appeal it or review it, it goes to the Health Professions Review and Appeal Board. So in the past, I've appeared before that board on behalf of patients who felt that the decision of the respective colleges were not adequate or reasonable as it related to the complaint that they had against the person. And so we went to that board. Pre-COVID, the board would have an attendance in person. There'd be 3 people, usually all lay people, former lawyers, not necessarily medical people. And it would be a day hearing where you'd represent your client and have them give some evidence, and you'd make some arguments. I mean, I find all tribunals, I've been to the WSIAT, I've been to the LAT, I've been to FISCO, I've been to CPP appeals, Social Security tribunals, landlord-tenant tribunals back in the day. And I find they all have a similar kind of informal vibe to them, where the rules of evidence are not so strictly enforced. People are, I think the adjudicators who are presiding over the hearings really kind of want to, get the facts out and try to decide the issue in the most fair way possible. So one of the things I've always noticed is it's a bit of a free for all. You kind of come in, no one's trying to get away with stuff, but it's, your client comes in, they'll say a few things, everyone will be asking questions, and ultimately the person making the decision will have to make the decision. I think one of the advantages to tribunals, and obviously why they tend to exist, is the specialized nature of them. So you're not appearing before a judge in your medical malpractice trial who practiced family law for 30 years, and this is their first time dealing with not only medical malpractice, but any kind of personal injury case, and they have a lot of learning to do. When you're at a tribunal, the adjudicators typically have a tremendous amount of specialized knowledge about the subject matter, and I almost feel like getting through the facts and everything is more of a formality for them to ultimately get to their decision, which I think they're very well qualified to make.
Now about that, in terms of, I don't know if you had any background in before law school or something in terms of, any biology or medicine or anything like that. How important does it come when you're doing very specialized cases like that? Understanding, sort of the treatments or sort of the medical theory or anything behind that, or is that something like you can solely rely on in parsing through the expert reports and things like that, or whatever you have to do?
I think that's probably the most important thing, is understanding the medicine. You can't do this job without it. Um, and no, I didn't have a background in biology at all. I was interested in criminology, and that was what my undergraduate degree was in. I think it's hard but easier than you think. So I always tell the doctors who come to testify, because whenever I've done a medical malpractice trial, my experts are like, "Oh my God, I can't believe how much the lawyers know about the medicine," and it's almost intimidating for them. And I explain to them that what the lawyers do is we study a very discrete, specific issue in medicine to the same degree that a doctor would potentially know about it. But it's so limited and it's very specific to this case. Over time, when you learn specifically about this issue, that issue, it's almost like a big puzzle that starts coming together, and you can kind of see the bigger picture. But when you first start out, you're just learning very individualized aspects of medicine, but you're learning it to a very high level. And so as a lawyer, and so as a judge and trier of fact, ultimately in the trial, and you become an expert on a particular issue. Everyone does. But if you are intimidated by that, or if you feel that it's not something that you're able to get your head around, I think you'd have a very hard time practicing in this area of law. Because like I said at the beginning, medical malpractice is less about the law, and it's more about the medicine, the facts, and being able to, I think, take complicated medical issues and distill them into more simple, digestible facts, so that people can understand where the malpractice happened and how it caused the harm to the patient, without getting overwhelmed in details that are not so important and may distract from the case.
Now, on that point there, where we're comparing the informalities of a tribunal, but the specialized nature of it versus a superior court trial before a judge. Let's just look at a judge alone for now. Is there a different style in terms of how you're preparing then accordingly, given one is more specialized and informal versus where a judge, like you said, might have been with experience in family law, and this might be one of the first times that they've had a case of medical malpractice? How do you kind of adapt to that situation?
So whenever I do a trial, I always prepare a few things. One of them is a glossary of medical terminology. So I get all the words in the medical records on the particular case that I'm presenting, that I think someone who's looking at it for the first time is going to wonder what it means. And so I put together a glossary. Usually I use Wikipedia or a medical textbook. If I'm stumped on how best to define a term, I might ask my expert. And then I'll send it to the lawyers on the other side, and I'll say, do you agree with this terminology, and do you have any suggested changes? I've never had an issue with it. Usually they say, yeah, that's fine, that makes sense to us. And so that's one of the first things that gets handed up to the judge, is a glossary of medical terms. The other thing I like to do is medical illustrations. Even if it's something that you would assume someone would understand, like something like a hysterectomy, you kind of understand what a hysterectomy is, but it's actually kind of nice to have a customized medical illustration that sets out the issues with the hysterectomy that you're bringing to the table with this particular case, and have it set out. It's a little expensive, but I find that it does help, particularly with juries, but also with a judge, to while people are explaining things, to have some kind of visual cue or visual depiction in front of them to help them kind of anchor what's being said into some example that they can refer back to. So those are the two big things that I like to do. And the other thing is, I try to simplify the case into, more of a story, something that's interesting, something that maybe would be on Grey's Anatomy. Like it can't be all technical, even with a judge, because I think there's a human element to it, and it's not just the patient, it's the doctor, right? This is a story of, someone coming to the medical system and coming out with a really bad outcome. And I think we all hold doctors in high regard, and we should, because they're very specialized and they're very well-meaning. And, there is sort of a uphill battle to a degree to convince a court that someone was negligent, a professional, educated, well-meaning person who helps people for a living. You're coming to court and saying was negligent and should be ordered to pay money to someone. And so there's kind of a delicate way of framing the narrative to be compassionate for the patient and to get them compensation without necessarily coming out too harshly against the physician to the point that you would reject effectively an attack on the physician's character or reputation. But you still need to get that finding of negligence so that your client can be compensated.
And now then, obviously with the Superior Court, there are judge alone trials and jury trials. Can maybe kind of what's sort of the process if there's situations where there has to be a jury trial or if it has to be done by a judge, and kind of what the process and if going between either of the two of them?
So in civil cases in Ontario, it's the parties who get to choose whether they want to have a jury or not, and any side can choose simply by filing a jury notice and paying a fee. I think of maybe $300, which I forget what it is, but a very small fee. You can have a jury. Typically, in medical negligence cases, the Association of the Defense Physicians don't file jury notices. They tend to not like juries. And on the plaintiff side, there's, I'd say, mixed sort of feelings on the plaintiff's bar in medical negligence, whether they prefer juries or not. Some lawyers do, some lawyers don't. I personally tend to prefer a jury in a medical negligence case, so long as my client is sympathetic. And I think I have, a pretty good case, but that's most of my cases I think are pretty good. But if I feel it's a pretty solid, straightforward, simple case in terms of what the issues are, then I do prefer a jury. The difference really is, obviously the length of time is different and how you present the case is different. I like the jury cases for a couple of reasons. One, because I think it does lend itself more into sort of this narrative that I was talking about earlier, that, judges kind of just are like, what are the facts? Give them to me chronologically, show me the exhibits, state your arguments, and show me the case law, and then leave me be and I'll make my decision, right? So your ability to be persuasive in the way that you might want to be is a little bit different with a judge than with a jury, whereas with a jury you have a little bit more leeway to humanize everything and focus a little bit on that, which I think is a little bit more fun and a little bit more persuasive. And I think it's a little bit more beneficial to plaintiffs who've been seriously injured in medical negligence cases. One of the other big reasons why I like juries is you get your decision right away. You don't have to wait 6 months. You do your case, they go and deliberate. It's obviously, a horrible time to wait, 6 hours or 12 hours, how long you have to waiting for your decision. But then you get it, and it's basically done. Appealing jury decisions is very challenging. Court of Appeal gives a lot of deference to jury verdicts. And so, and the Association of the Defense Doctors is well known for appealing, decisions. So this gives you sort of an added layer of protection that if you do win a jury verdict, you're probably going to keep it.
And you said it's just only one, like if one party wants one party doesn't, then the position is that there would be a jury trial?
Unless the party that doesn't want it is successful in striking the jury. So, getting to COVID, jury trials were suspended and they're back on now officially with modifications, but they were suspended. And so there were, parties on either side that didn't want juries that were looking to use that as a reason to strike juries. And I think some were successful. I don't know in malpractice if any were successfully struck, but it's possible. But I know in the motor vehicle accident sphere, some juries were struck and trials proceeded by judge alone. And so, they can get struck. Now, in the 90s and earlier, juries were struck more often by the doctors successfully by convincing the judge that the malpractice cases were too complicated and that the lay people wouldn't get it and it shouldn't be put before a jury. And I think appropriately the judiciary has moved away from that. And I think probably the best reason is how is a judge in any better position than a jury to understand the medical issues, really? I mean, it's not like judges are specially trained in medicine either. So if we're looking to, decide whether a jury is in a good position to decide this versus a judge, I think they're both in the same. And given our rights to have a case tried by a jury, if that is our choice, it should be upheld.
And is it like criminal law with, does the jury have to be unanimous in their decision, or can it be split like by a majority?
So in a civil jury, there are 6 people. And what happens is a jury gets a list of questions. And to each question, they have to answer at least 5 of 6. So it doesn't have to be unanimous, but at least 5 of the 6 have to be in agreement. So what you would do in a jury case in medical malpractice is at the conclusion of the case, they'd have a list of questions. And the first one would be, did the defendant doctor fall below the standard of care? Yes or no? And so 5 of the 6 would have to answer, would have to agree on either yes or no. And then if they do, then you go on to the next question and so on and so forth.
Okay, so I know we just talked about this a couple of questions ago in terms of, if you do have a jury trial, and again, it's not very common as you pointed out there. I mean, or even going to trial is not very common there. But what can you share from your experience in running them with, maybe junior practitioners who may have a situation where, again, maybe it calls for a jury trial and they're doing it maybe for the first or second time. Any sort of tips there that would kind of help as you look back on the ones that you've done over your career?
I think probably the best thing to do, and I found myself doing this probably, to the exhaustion of my friends and my family, is get used to pitching your case, and try to think of it as like the elevator pitch. So imagine you're in the elevator, you got from the first floor to the 15th floor to chat up the person in the elevator with you and convince them that the case you're taking to trial is one that you're going to win. And not being misleading or unfair to the facts, right? You know what the facts are, so you're not going to tell them something that's untrue. So practice that. Practice with your parents, practice with your significant other, practice with your friends. You're having dinner, you're having a drink, you're playing sports, whatever you're doing. Say, hey, I got this case coming up I'm going to trial in a few weeks. Your friend says, oh, well, what's it about? Well, this is what it's about. This doctor did this to my client, left him in this way. My God, I can't believe that. I can say, I know. And you can kind of start gauging how people react. It's almost like mini focus grouping, right? Because you have to remember, the people that are going to be on your jury are going to be, 6 random people off the streets. And you need to kind of practice tuning into what I would call the common sentimentality of people in Canada, Ontario residents, because you need to get them thinking in that way, that you're right. And the only way to do that is to understand a bit more about how we as a society think about things, how we think about fault and responsibility and healthcare and compensation and the civil litigation process. All of these things are things that people bring to them into the courtroom. And so you need to get a sense of how that's going to play out and not take anything for granted that people are going to automatically believe you or be sympathetic to you. In fact, some people could be hostile. They might not like lawyers. They might not like people who sue for money. They might not like patients who take oxycodone. You don't know what kind of prejudices are out there. So it's good to kind of play them out with people before you get into the courtroom.
And we were talking about COVID as well, and maybe you can tell us about how, since the jury trials were suspended, if you had any trials that were with the judge alone there over the last year and a half, how have they been conducted, and how would you compare that versus pre-COVID in terms of preparation and effectively advocating on Zoom versus in person?
Yeah, I haven't had any trials. I've had a couple contested motions. Yeah, it's different. I think one of the things I did like about it was, using Zoom and then sharing my screen and bringing up evidence in front of the judge and the opposing lawyer, using PowerPoint or whatever PDF documents. I found that a little easier rather than, referring to documents and paper briefs and stuff in the courtroom. I don't know if I liked it that much. For like a motion, it was fine and it was convenient. There's something about being in person that's better. And I couldn't imagine, you can't, I don't think anyone's doing Zoom jury trials. So the jury trials are being done in person. But I just find even, I've heard of, there being jury trials, but the witnesses are appearing by Zoom. And I just find that kind of interaction to be suboptimal. And it's, hopefully something that's, we're going to return to in the not too distant future. And, I think there's going to be a lot of changes because of COVID, and working from home, I think, is great. And there are certain things that, by video conference are better, and they save people travel time and more convenient. And there's all kinds of good reasons for it. But I do think when it comes to that feeling in a courtroom when someone's being cross-examined and you know that they're on the ropes or they're not being truthful, you just don't get it the same way by video conferencing. So, I haven't done a full trial, and some of my partners have, and one of my partners is at trial in Welland right now. But I feel like I don't think it's the way to do it.
And I guess the same thing with any discoveries or anything like that. Would you feel it's the same thing there, or is that you think maybe motions could be something you can do, but pretty much everything else seems to be something that you need to do in person?
Yeah, I mean, discoveries. I've done a lot of discoveries by Zoom, and when they saved me from having to travel to like Sault Ste. Marie for 3 days, I really liked it. But then the video was cutting out. There's connectivity issues, and I feel like it was more convenient, but still it wasn't quite the best. But I think, I think it's good. I find like even discoveries are tiring, for lawyers who do them, and anyone who does civil litigation, young lawyers who are getting into this, I can tell you, you're working at a busy firm, you're going to be doing lots of discoveries, lots, 3-4 days a week of discoveries. And it's a grind. And, being in person at, network or some other discovery place, and being able to get up, stretch your legs and network with people and get a coffee or bite to eat, to chat with the other lawyer on the breaks, that's, over the years where I made a lot of connections with people in the personal injury bars, just by spending time at a discovery office. And so now we're all, segregated into our homes and on Zoom. And the second, there's a break, you're shutting your screen off. You don't have that same connectedness that you had before.
Now, Paul, one of the things, and I think you brought it up there in terms of, when you start off, you're going to be doing a lot of discoveries, but I think it's, again, probably it's unique. Although when I went to law school, everyone kind of thought that's the path, right? Is that you're going to get a summer or articling job at a firm, and then you're going to be hired back and slowly progress up and become a partner. But that's sort of the trajectory that you've had here. And at any point, did you feel that there's something else? I know you talked about your criminology and you were doing criminal defense, in the legal clinic before. Have you ever thought, there's something else out there for me? Or were you sure kind of as each step went along here that, this is exactly where I need to be and what I like doing?
Yeah, I think I've been lucky in terms of my legal career, because I've for sure seen people through, in law and colleagues and friends struggle with their legal career in terms of not being sure if it was what they wanted to do, and maybe leave the profession of law to pursue something else. For myself, I've been really lucky. I really have always enjoyed what I do, and I take a lot of pride in what I do, and it's just something that I've always kind of came naturally to me, I felt like. So there's no other careers I really wanted to. Obviously there's things I like to do other than be a lawyer, but in terms of, realistically, this has always been what I've enjoyed doing. And yeah, you're right. I followed a pretty traditional path. I'm still at the same law firm that I was almost 20 years ago when I started practicing my article here. And so there's a certain comfort and familiarity of having that course. But I wouldn't say that is the course that everyone should be expected to take. If I'm going to give some advice to young lawyers who are coming out into the profession, you have to know that different areas of law are completely different. It's sort of an obvious statement, but what I do on my day-to-day is completely different than someone doing business law, real estate law, family law, corporate commercial, municipal, all completely different. And then to add a layer to that, depending on what firm you're at, the people you work with is going to be completely different. Some firms are laid back, some are really, hardworking, some are very competitive, some are very help with mentoring, some don't. Some just throw you into the water and hope that you can swim. So everyone's experience is different. And I think, and not to say anything's bad or good, it's just depending on who you are and what your personality type is like and what you're interested in, you might find certain types of law, certain types of or firms, whether they're big or smaller or somewhere in between, better suited for who you are and what you want to do. And I think one of the things you need to do is, if you're feeling like it's not the right place for you, like let's say you get off and you're, working whatever you're doing, you're like, I don't know if I like this. I don't like, in personal injury, some people don't like the clients. They're demanding, and it can be challenging. And that's one of the things I hear from junior lawyers is like, I don't know how to deal with this person. They're always calling me up and complaining. Maybe it's not quite the right job for you if that's if you can't handle that. And not to say that it's something you can't learn, but some people just don't want that. I mean, people want to have a corporate client they can meet over lunch, and that's how they like to interact with their clients. So I think you need to be true to yourself and not be afraid to make a move, before you get 10 years in and hate your life because you hate your job.
Now, you mentioned that I'm also teaching practice management right now, and you talked about clients there, and maybe anything you can share in terms of when you might have some very needy clients who are calling. I mean, sometimes obviously the process, goes from the injury to a potential trial. I mean, there's a number of years there. How do you kind of handle client expectations and explain? I mean, even as you gave an example before, well, if there's no expert that's going to really say there's an issue here, then we don't really have a case. How do you kind of deal with handling clients and handling client expectations and, all the various related rules there of professional conduct from the Law Society?
Yeah, so I try to be, I am very upfront with the clients. So I explain to them how difficult medical malpractice cases are. I explain to them that, we're not seriously pursuing a lawsuit until we're sure that we have the experts that, we need. And yeah, I have disappointed clients who may pay a monetary retainer or may just hope that I would be able to find an expert, and I have to tell them that I can't, and that I don't think that they have a viable case, and that I can't help them anymore. And they can either see another lawyer or they can abandon their claim. But I unfortunately can't do anything more for them. And yeah, that can be very disappointing for a lot of people. Some people take it better than others, and some people get very upset and mad and turn around and blame you and say you didn't do a good enough job, or there's something wrong with what you did. And that's honestly just part of the game. I think having good communication, having the important parts of it in writing is really important. Not only to protect yourself, but maybe to refer the client back to what you told them originally in terms of giving them expectations. I think most people in personal injury know that there's a certain level of unpredictability, and you would be doing yourself a huge disservice, including your client, if you made promises you couldn't deliver on. But I think on the other hand, we have a responsibility to not give completely wishy-washy advice. And that's always been a pet peeve of mine, is people who, lawyers who really kind of give you the whole gambit of potential outcomes and anything could happen. And, I do like, to give a little bit of my opinion about what I think is most likely, what I think they should do, what I think is the best option. And I'm prepared to be responsible for it if I'm wrong, in the sense of, it's my time, it's my firm's money that we're investing into this case. So, I can say to my clients, I'm recommending you proceed with this lawsuit. And I'm not just saying it because, I want to, bill you by the hour for it. It's, I'm not going to get paid unless we recover money in this case. So I'm not going to be recommending that we proceed with lawsuits unless I think there's a good prospect of recovery.
Now, Paul, one of the things we've talked quite a bit with many different guests is in terms of taking care of yourself, right, before you can take care of your clients, and especially in big law, right, especially starting off for young lawyers, they may be carrying a lot of, you mentioned the discoveries, a lot of hours, billable hours, a lot of work, and as you alluded to, that for some people that they may realize, hey, this is not for me, it's too much. What can you suggest, or what maybe from your own experience in terms of finding time, to take care of yourself, take care of your mental health, especially in big law, that you can share with young lawyers and students that are listening?
Yeah, I think that's essential. At our firm, we've always had a good work-life balance philosophy. When you're at trial, you're going to work, 18 hours a day or whatever you have to work. But we're not at trial all the time. Maybe it's once a year, maybe twice a year on a busy year. It might be for about 2 or 3 weeks. But for the rest of the time, I think it's really important to exercise, eat well, spend time with friends and family, have hobbies, have interests. I don't think it's healthy to be all consumed by any one thing, particularly the law. And if some people it's what they're like and that's all they want to do, and that's fine. You can do that if you want, but it certainly wouldn't be something that I'd be recommending to someone. I think mental health is hugely important, especially in civil litigation or any kind of litigation, because we're always fighting with people. We're fighting with the other lawyers. We're fighting with the clients. We're fighting with our experts. We're always trying to get people to agree with us, and they don't always want to agree with us. And you need to have thick skin. You need to have energy. You need to have fortitude to deal with that, because it's stressful, and especially when you have a lot of things going on. It can, for some people, become overwhelming, and that can be counterproductive to what you're trying to achieve. So I really think that it's really important to keep that balance. And for me, it's, I got my family, I got my friends, I like to exercise. There's a lot of interests I have outside of law that I like to pursue. And I think that keeps me sane.
Perfect. So thank you so much, Paul, for taking the time here and joining us, sharing about medical malpractice and your career there and advice there for young lawyers, students, and anyone listening. I was wondering maybe if you could end with any final words of wisdom for those looking to get into the profession, maybe looking to get into civil litigation or personal injury, or maybe even specifically medical malpractice one day. Any words of wisdom that you can share with them. And thanks again for joining us.
Well, thank you very much for having me. It's been a pleasure. And all I'd say is, do what interests you. If you're interested in medicine, you want to get into it, you should do it. If you're interested in technology, get into IT. Do what interests you, because you're going to be spending a lot of hours of your life doing that, and it should be something that you're really passionate about.
Perfect. So thanks again, Paul, for joining us, and take care, and wish everyone tuning in all the best, and hopefully see you again tomorrow. Take care.
Okay. Thank you very much.